particularly the way that being a lesbian takes away from women's ability to make asylum claims. So I've learned a little bit about gender and asylum claims and gender and refugee determination and refugee camps. And a lot of the things you were describing seem to really apply to women as well. The difficulty proving persecution, the difficulty establishing the contact, which you're told is too normal, it couldn't have happened. Of course, you were raped, that's what they do in your culture. So I wonder if you could say a little bit more about the ways in which lesbians in particular are disenfranchised. Because it sounds to me like what you were saying was that compared to gay men, it's harder to establish the narrative. But it seems like it's similar in difficulties to the way that women who experience gender-specific persecution. They have similar challenges in proving asylum in the U.S. because it's so arbitrary. So could you say more?
Yeah, absolutely. I mean, I completely agree with you that the challenges are very similar. That in some ways, lesbian asylum seekers are not unique when we think about the broader category of cisgender women and the struggles that they experience. I think, and in a broader project, I make those connections, I think, a little bit clearer because I'm tracking the construction of gender-based violence as a concept in U.S. Law. Let's figure out where this is supposed to be.
Yes.
There's no feedback. But I was interested in the lesbian cases because they're claiming asylum under sexual orientation provisions, so the Toboso-Alfonso ruling from 1994. So I was really interested in how does then that articulate for lesbian asylum seekers. But I completely agree with you that when we broaden the category out, you begin to see that this is something that many women experience no matter what the claim is, and in large part it is because of the male model that really frames how asylum law, I think, is articulated and then implemented. So the public actor speaking against a state, et cetera, et cetera. And then also the way that gendered forms of violence that target women in particular are intelligible as private violence, as sexualized, as fitting within a framework of desire or fitting within a framework of power over women, which still, again, gets interpreted as private, I think, as the cases play out. I hope that answers your question. Thank you.
Yes, Sarah, sorry. I also have kind of what's more of a comment for Sarah, but the thing that I think I appreciate about your title and what's so interesting about what you're thinking about is, as you were speaking, I was also thinking about the ways in which victimhood is constructed around lines of nationality and ethnicity, and the fact that so some of the cases that you shared, particularly the women from Central and South America, the women from Uganda, where I also see the intersection of their viability as a victim of persecution at all being in question because of their racialized identity in the view of the U.S. Judicial system, and how that's sort of also, that's working at the same time with their gender and with their self-identity in terms of their sexual orientation to sort of undermine their viability for admittance into the country. I just thought, there's so much going on there.
Yeah, that's right on. And that was one of the things I was really struggling with as I was composing this chapter, is how to really draw the various nuances of intersectionality that are absolutely at play in each of the cases, because I'm looking across a wide range of context of persecution, and so that kind of macro frame made me struggle a little bit. But I think you're absolutely right. So the cases from Central America, we cannot not read those cases alongside the ways that Latino, Chicano, crossings get framed within racialization and also framed within class in terms of U.S. immigration.
So then it's interesting that Rachel's cases from the 50s are all men that presumably are white gay men, and it makes you wonder where even were the men of color in the 1950s who were experiencing the persecution of the immigration system. Like, their stories aren't even in the record, right?
Well, so yeah, that's a great point. That's definitely part of the piece I'm writing. It's very striking. So they're all Canadian or European, white men with, lawful permanent residence status. I mean, in sort of the hierarchy of immigrants, they're right up there at the top. And I think that what was happening, I think this is the other way that it kind of foreshadows in a way the current immigration era, is that those people were being given due process, right? As you said, so there were, this is the era of the Operation Wetback, of like mass deportations of Mexicans without regard to what their actual status was. Sometimes you get U.S. citizens. I've read another pieces about that. I mean, and so I think not that, and I'm a big critic of. I mean, I would not say that there is a lot of due process protections within the immigration system now, but you don't have, I mean, people do go through the system, everyone does go through formal proceedings now in a way that in that era, what you're seeing is how do you get to these people who you do have to put through these proceedings, and the way you do it is through the sort of this police involvement, and then I think that gives us a kind of sense of now that how that's happening now on this broad scale, post-civil rights movement, when we sort of have a situation, I mean, there's been some really interesting work about immigration that I'm going to integrate into this that is sort of linking it to in post-1965, the national origins quotas get taken out of the immigration laws, so the kind of the obvious racial restrictions on immigration laws go away, and so suddenly the racial composition of immigrants changes radically, and sort of how the war on crime then kind of gives rise to this way to deport people.
Hi, Lori Lefkowitz. I thought those were so interesting. I wonder if you could talk at all about what it was that shifted in American law self-understanding in the trajectory between these two. I mean, in the one, you have America self-representing as a place of asylum for people who are persecuted elsewhere for crimes of sexual crime, and in the earlier moment, you have people who are otherwise perfectly qualified as immigrants, but are being deported for reasons of sexual crime, and somewhere, or not. I mean, I feel like both things continue to go on at the same time in our self-appreciation as a legal system and in the right.
I mean, I think what's fascinating about that, so I would argue that, I mean, the asylum system is framed as this humanitarian ideal of the West, helping these folks in trouble, blah, 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 when in fact it's used as a technique of deportation and to exclude. For me, I think that tension is really necessary to always keep in the mind that there is a fiction that goes with the notion of asylum that is produced by numerous exclusions and numerous deportations.
Yeah, the irony of that, it's not lost on people who were concerned, but I actually hadn't really thought about how it's so present in this one panel, and there was this awkward moment. So the psychopathic personality actually, usually people talk about grounds of exclusion or deportation as kind of a one-way ratchet. So every time there's a panic, things go in there, but then even when the panic subsides, they don't never leave, right? And so you can kind of see this like accretion of all the panics of the the 20th century kind of put in there. But the psychopathic personality is actually one of the few exceptions. So it got changed to sexual deviance in 1965. Then it gets repealed. It gets taken out of the statute in 1990. And 1990 also happens to be the first, the year of Todos Alfonso. I mean, it didn't get publicized until 1994, but it's actually the same year that the sort of precedent-setting gay asylum case comes out. But there was this awkward period actually where they overlapped, because Todos Alfonso, actually, his original hearing was like, he originally got granted in like 1988. So there was this period where we were keeping people out for being gay, and yet giving them asylum if they were gay and had been persecuted elsewhere. So there's a rich story there, and I think, I mean, there are ways. I think you could put a queer kind of a spin on contemporary queer immigration. I mean, that's sort of the criminalization of sex work, and there's certainly people within the queer community who are very much targets of this regime now. But on there's also that kind of if you look at the sort of I mean, like Jasper Poir's work, and that there's sort of also this glorification of a certain kind of gay subject, right? That gets cast as that's done a flip in immigration law that like no other community I can think of, right? So from being completely excluded and hated to now being kind of the symbol of our enlightenment. But again, the same thing for the gender asylum cases, right? Like all the sort of gender human rights issues, it can be a way, if you're coming from a Muslim country, like there's a way that this country likes to sort of see certain women as very oppressed and in need of being rescued, and yet, the asylum system continues to in fact be very inhospitable to gender claims in general.
Thank you.
For those of us non-lawyers in the room, I wonder if you could just tell us a little bit more about the overall process, because I heard this piece on NPR with like the judge who's the president of the Association of Immigration Judges, and she's talking about some of the time lag in the backlog of how long it takes for your case to be heard and how many people go actually unrepresented by legal counsel. And so I was just curious, between the asylum cases and the immigration or deportation cases, what you could tell us just about the processes. I was kind of blown away by everything that she was saying in that respect.
You can look at where.
Right. So I mean, so asylees. Although I mean, this is not a system that's great to asylees, and we don't. A lot of countries, for example, give asylum applicants lawyers. We don't do that. There's no right to because immigration law is considered civil and not criminal. There's no. You don't have any like the Sixth Amendment rights that you have in the criminal system. So you don't have a right to. You have a right to hire an attorney, but you don't have a right to an appointed attorney. And like among detainees, which is a huge number of the people these days are subject to detention, not 84% of detainees have no lawyers. So I mean, this is a system that is just full of people with no lawyers. But within this system, I mean, it's still true that asylum seekers are the most sympathetic, probably, of the people who are coming here, and folks I deal with, the people with the criminal convictions are absolutely the least sympathetic, right? And they're subject to mandatory detention, and they're transferred all around the country. They get transferred down to the town of Texas and Louisiana, where the case law is terrible. So they get taken, they might get taken into custody in a place like New York or Boston or San Francisco, where there's a lot of pro bono lawyers who might help them, and maybe some good case law in the circuit, in the federal courts. And they all get detained down in Oakdale, Louisiana, or Harlingen, Texas, where there's, they have little chance of getting an attorney. The law is really favorable to the government. The government has complete control of this, right? It can transfer people as much as they want. So there are massive, massive problems, and there's because of this unbelievable rise in immigration enforcement. There's also these backlogs. I mean, the system is straining under this incredible load where this all these people coming up through the jails and stuff. It's a huge increase. So it used to. I mean, many years ago, the early '90s, the affirmative asylum claims used to be taking often years and years, and actually it was sort of a good deal in a way. Like you could come and say, I'm seeking asylum, and you get work authorization, and then they'd kind of forget about you for years. And so there was concerns that people were abusing this system, and so they actually switched it to say you don't get work authorization, but we're going to do them really quickly. So now people don't get work authorization. For a while they were doing them very quickly, like a month and a half to get your hearing. I mean, for a firm like someone who's just not in deportation proceedings but was just applying. Now, though, they've got huge backlogs there, and people don't have work authorization. So it's a terrible kind of combination of those two things are supposed to go together.
Yeah, absolutely. I second all of that.
Yes, you can.
Yeah, I'm trying to formulate this question, Sarah, to you pretty much. It's so interesting. One's a practical question, and then one's just to ask you to elaborate more. I wonder, the practical question is, has there been, because of this sort of unrepresentability of the lesbian asylum seeker, all right? Has there been a strategy to turn them into gender asylum, of course, in cases? So has there been a move by lawyers saying, look, this is going to appear to the judges as gender-based violence. That will look that's representable to some extent, even though it's privatized, even though all of the stuff that goes with that, it's a knowable entity. Should we just go that route? So that's one sort of practical question. And then the broader question is, do you think there's a way in which the sort of signifiers of sort of female, of women's masculinization, which is what they would understand as the sign of the lesbian, right? Mm-hmm. That those signifiers work differently than the signifiers of men's feminization. I mean, I think about this in the discussion about Putin, and I mean, is there just a way that those are not, that one of the things that I drew from it is that it's important to sort of disarticulate, these are not parallels, right? Because of, oh gosh, the patriarchy again. But they're not, right, that they signify in non-analogous ways. Yeah.
So in regards to the second question, absolutely. I mean, I think that in some ways it's about what does it do, what does women's masculinization or men's feminization do in terms of the social imaginary and what it ruptures. And I think there's maybe more of a rupture with men's femininity because of heterosexual logics, patriarchal logics that really undergird our thinking about gender and sexuality. So yes, I think that nuance I think really needs to be probably articulated more in this presentation and in the paper. So I take that point and I will work with that. In terms of the practical question, there has been a recent strategy to turn to gender-based violence. So one of the things that I've been seeing from some of the organizations like Immigration Equality, I mean, there's a number of organizations that are really doing work with LGBT asylum, is to say that, okay, lesbian isn't working as a framework, but a lot of these cases include forced marriage, for example. The Maldonado Lopez case that I cited, and there's forced marriage. There's a number of elements that maybe articulate better as gender-based violence, and so I've seen in some of the briefs in support of that case in particular, arguments are being made in that way. That case is still being decided. It's still being evaluated. So I think we'll have to see. But practically, I come to this as a rhetorician. So I'm very much interested in how do we construct arguments? How do we use language? How do we construct a frame? As Peter was talking about in the earlier session. And I think that might be an interesting one to combine those. And in fact, it's the intersection of gender and sexuality that they're kind of working with in that case. So we'll see.
Can I jump in a little just from practice? So it's an interesting question, and I think that the term to gender claims has been part out of necessity in the sense that if you look at the evidence in a lot of lesbian cases, what is happening to them, it's in some ways they have more grounds for making a gender claim, and that is, right, they've stepped outside gender norms in some way, and they are, and so that they sound more like gender claims. So you kind of need to go that route, but in terms of the doctrine, you don't really want to. So here's the deal: the jurisprudence is actually very clear on the gay, back in 1990, the Board of Immigration Appeals said sexual orientation is a particular social group, because there's only 5 grounds. You have to show that not just that you're persecuted, but that the persecution is to overcome a protected ground: your race, religion, nationality, political opinion, or particular social group. So then, well, what's a particular social group? So being gay is absolutely a particular social group, no question. being a woman is not a particular social group. The BIA has said no to that. And so the domestic violence cases have been very hard. Well, what was I being persecuted for? It's hard to find what's the group, right? The Rodi Alvarado, the big high-profile domestic violence case, the board said, your husband wasn't going after you because you were part of some group. He was going after you because you were his wife, and they refuse to see this as sort of as patriarchy. And anyway, and so in fact, the gender claims often try to get framed as other. People try to frame them as other things. So there's like Matter of SA was a teenage girl from Morocco whose father was trying to control her. Basically, he thought she was, kind of loose and, he caught her stepping out one night with some boy or whatever, and he was brutal to her, right? It was a domestic violence kind of a case, and it was clearly patriarchy at work, right? But the winning argument there was religion, was that, she had a different interpretation of Islam than he did. And that so she was being persecuted on the basis of her religion, which was kind of crazy you could find that in any religious tradition. It was so clearly that it wasn't about the religion, but that was an easy argument to make, right? Because it was Islam, and because religion is clearly, protected, whereas trying to bring that as a domestic violence or a gender kind of a case was not going to fly. So I'm not sure that the way to rescue the lesbian claims is to go into the gender. Everyone's kind of fleeing from the gender framework if there's a way to.
So trying to listening to you of how you would track the rhetoric of America the Great, through this. And it seems like on the one hand, asylum is about things are horrible in the rest of the world, and this is a point of saving, and in yours it's like you're not living up to the great standards of the US and we will send you back. So has the gap between these two always been the same? Does it narrow, become greater? Sort of the dissonance between those two? Between asylum and deportation?
I think they're becoming one. In some ways they're becoming one and the same. I feel like asylum is becoming more, it's limited and limited, right? And so...
And deportation is growing.
And deportation is growing, right? And then there's also this move, I'm sure you all saw this, so I think it was 2012, the State Department alongside USAID outlined the global strategy to eradicate gender-based violence. And really, it's like, all right, let's use USAID and military to eradicate gender-based. I think in some ways there's an extension to, like, let's not bring people into this country. Let's find any means not to. And so saying that we can make it better there, and sort of this interventionist strategy for me is the direction that I'm seeing it. So in some ways, the image of harboring those vulnerable still continues. That discourse still remains, and yet asylum becomes more and more and more limited.
It's not something I hadn't ever really thought about that way. It's an interesting thing to try to figure out. And one thing I would say is they have different timetables. So because refugee and asylum law doesn't really, the Refugee Act is 1980. But we signed on to the protocol in 1968. So I guess you'd say from 1968 on we had asylum in this country, but we didn't really. We had some kind of interim things after World War II, but it's all post World War II. And so, the heart of immigration law is this sort of exclusion and, keeping people out. And then this is this new regime, but it's interesting because right as we start to have this new discourse of sort of we're going to welcome people and have this humanitarian asylum, and you can see this not just asylum, but U visas, where there's actually been a growth of humanitarian kinds of visas. So we have visas for victims of domestic violence. We have visas for trafficking victims. Right when you have this growth of this kind of humanitarian end of asylum, you actually have, in the deportation system, the destruction of all the discretionary measures that were in there. Because if you look in the 30s, 40s, 50s, the key thing about the deportation system is that there were, people might have been deportable, but they could always be given a second chance, right? That's really what changed in 1996. Is now there's people who are just automatically, you got one conviction for dealing, for attempting to sell $5 worth of marijuana, you're subject to mandatory deportation. There's no second chance. Whereas for decades and decades, it was always the case that you might be deportable, but no one would even bother with your case. And if they did, they'd look at it and say, well, we'll give you a waiver, you can stay. That's all been taken out at the same time that now there's these new kind of, we're going to say, save these people. And so it's an interesting tension to think about.
Yes.
Laura Green again. In a way, I suppose it's a comment, but I mean, it's a fabulous panel. It's really depressing me because what I'm seeing more and more from what people are saying is that it's not even a convergence or a tension or a paradox, but really what you're saying is there is one ratchet, right? I mean, the state has a ratchet which it turns to control the numbers and kinds of people who flow in and out. And this ratchet has little different bits and pieces. So it has a bit that it calls asylum, and it has a bit that it calls immigration, it has a bit that it calls deportation, but it is one big government screw, and you can always adjust it, right? I mean, and sometimes, I understand there are really, really good people, such as a lot of people in this room, who work on, trying to push back the government adjustment in this way, or take advantage, make it spin around a little bit this way, but it seems to me that what we're really talking about is the incredible power of states to keep people, I understand that, of course, we're talking about it because this is the topic, in fact, but I don't know, it just suddenly struck me how absolute this power seems to be. So I know activists are in some ways always more cheery than that, or you wouldn't be able to do what you do. So maybe someone can say something a little more optimistic.
Okay, I'll try to cheer us up a little. I don't want to lose it. So if you work with immigrant victims of domestic violence, there's a lot of really positive developments that happened in the law over the last 20 years. There's things that you just couldn't do 20 years ago and you can do now because of the Violence Against Women Act and the immigration provisions. So, and then if you look at the Dreamers, this whole incredible movement that actually, I have to say, has this very queer. That's the one thing. It would have been great to have something on that. There's a whole undocu-queer movement. There's been this whole, and there's been this explicit drawing on kind of coming out of the closet, and there's been a lot of connections between queer activism and dreamer activism. But in any case, besides that, it is redefining the terms of the debate, I think, in a lot of positive ways. Lest we all go out here, totally. There is some really interesting, exciting stuff going on.